My name is Laura D. Hurd, and I own the Laura D. Hurd Law Firm, Inc. We have been practicing law here for 35 years, and I'm honored to serve San Antonio and surrounding counties. Child custody in Texas. That's a topic that's close to many hearts, and that's the topic that I'm diving into today. Hello, my name is Laura Hurd, and I'm an attorney who has practiced family law in San Antonio, Texas since 1987. And today I'm going to discuss the factors that are included in determining child custody in Texas and how to create a parenting plan that truly prioritizes the best interest of the child. Stay tuned. Here are some of the factors considered in child custody cases. If there are two decent parents and both want primary custody, that's a tough decision because the judges are not supposed to base their decision on the gender of the children or the gender of the parents or traditional notions of parent-child relationships. But we all know that some judges are still so focused on the traditional vision of a family that they find it very difficult to consider having the father as primary custody. However, when it comes to child custody in Texas, the courts are supposed to look at the best interest of the child. And the best interest, we all know, includes things like the child's age, their physical and emotional needs, and any existing bonds between the parents. The courts consider the stability of each parent's home. If one parent has multiple relationships in a year, in and out of relationships, or moves around a lot, then that tends to be very unstable for the child. If they have to change schools or they're in a different environment all the time, that's not good for the child. So that's something that the court will consider. The courts look at the parent's ability to provide a safe and supportive atmosphere for the child. The temptation in a child custody fight is to pick at every little flaw of the other parent in an attempt to make yourself look better and in hopes that the judge will find that you're the better parent and award you primary custody. That is a terrible strategy. And let me tell you why. First of all, there's no such thing as a perfect parent. And if you try to set yourself up as perfect and the other side, you're complaining about things that happen to all parents, it's just going to make you look bad. And parents' styles are typically either on the lenient side or the strict disciplinary side. Children really need both. They need strict disciplinarian parent and the balance of the nurturing, lenient parent. And if you're complaining because the spouse on the other side is one or the other, then the judge is going to see that as you're just complaining about someone who is a good parent. Just because the parent is different doesn't make them a bad parent. It's not a good idea to complain about every small detail of what the other parent does. The court is more impressed if you are supportive of the other parent, because it is important to encourage the child to have a good relationship with both parents and to strengthen that bond with the other parent. Make too good of a case that the child has no bond with the other parent. It can backfire on you. I have actually seen cases where the judge says, you know what? This child does not have a good bond with their other parent. They need more time with that parent so they can develop that bond and strengthen that bond. And so they end up making that parent the primary so that they can spend more time with their child and develop that bond that is weak. So it doesn't do any good to try to impress the judge with how weak the other side's bond is with the child if they are overall a decent parent. Don't pressure your child to make the choice. The courts are supposed to consider the child, what the child desires when it comes to custody, but they don't have to go along with what the child desires. They just consider it. And the child generally loves both of their parents. They don't want to have to make that choice. It's not fair to them. They're not the ones choosing for the parents to live apart, to be separated. Why should they have to choose which one to live with? So don't put that choice on your child. The judge is looking for you to be the adult and you to make those decisions as parents for the child. So encourage a relationship with both parents. It's really critical to understand that in Texas, joint managing conservatorship is presumed. It's the norm. And if you don't want joint managing conservatorship, if you want a sole managing conservatorship, the judge has to make an affirmative finding that the joint managing conservatorship is not in the best interest of the child. And so basically, you've got to show that the other side is not a good parent. And that should be a pretty rare situation. Yes, there are times when the other parent is dangerous. If the other parent is a sex offender, if the other parent is abusive physically or even mentally, or is totally neglectful of the child, or the other parent is an addict, then it may be that you have to ask for a sole managing conservatorship because it's not in the best interest of the child to have a joint managing. But for the most part, most people are going to get a joint managing conservatorship in Texas, whether they want one or not. So the best thing to do is to come up with a good plan, a co-parenting plan. And there are co-parenting classes out there. There are classes you can take online helping parents to help children cope with divorce. The judges love it when you take those classes. They are helpful. Tips for creating a great parenting plan. Now, let's talk about creating a parenting plan that aligns with the factors that the courts consider in custody situations. Remember, these factors are very broad in terms of child's best interest, but they do consider the healthy, stable home. Do the parents have encouragement for the child to have a healthy relationship with the other parent? They consider the child's age and physical and emotional well-being and what the child wants, and they consider all these things together in determining where the primary custody should lie. But the judge is looking for a safe and a supportive atmosphere. And how do you show that in a co-parenting plan? The first tip for creating such a plan is communication. Open and honest communication with the other parent is key, and a willingness to compromise. Discuss schedules, routines, appointments, holidays, sporting activities, after-school activities, important decisions about the child's upbringing, such as when they're going to go to bed at night and consent to join the military when they get of age. Clarity is your friend in these situations, so be very specific. If you're not specific, it's going to lead to misunderstandings in the future where one person says, well, you said this, and the other one says, I didn't understand that that's what was meant. That's not what I intended. So in order to prevent those misunderstandings, be very specific now in setting this up. Talk about things like, what are you going to do if there's an emergency or your car won't start or you're running late and you're not going to be there on time for the exchange, or you're going to miss a doctor's appointment? Do you inform the other parent? Is the other parent going to be considerate of that? And consider that flexibility is important. The child's doctor's appointments and school schedules and such, you need to communicate, and those things come up at random times. So one good thing in Texas courts that we encourage is the use of one of the parenting apps. There's two major ones that most judges will order if you ask them to. One is called Our Family Wizard, and the other one is Close App. And with Our Family Wizard and Close apps, they have calendars online that you could add in doctor's appointments, sporting events, homework assignments, projects, when things are due, when there's appointments. And you can communicate just like a text message, but it won't be something that could get lost, whereas a text message or an email could get altered or erased or taken out of context. The communications back and forth through these apps can't be erased. So you are preserving the evidence of the communication and exactly what the conversation said. These are good ways to help with communication. But of course, you have to be willing to communicate and to be sure and tell the other parent when homework is due, and the other parent has to be sure and check that app regularly to read what is written there. Navigating child custody agreements can be challenging, but remember, the child's best interest is the compass, so focus on that. And remember, even though you don't get along with your child's other parent anymore, it's the child's best interest to have a good relationship with both parents. So nurture that relationship with the other parent, even though you don't like the other parent. In the situation where a parent truly is a danger to the child's best interest, a danger to their physical and mental well-being, then in those situations, that's different. There's always exceptions. There are parenting courses online for divorcing parents, and they're highly recommended by the courts. Learn all you can about co-parenting while living apart. And if you found this video helpful, then give it a like and subscribe to my channel. That helps me out a lot. It helps me to make more videos if you will subscribe. And remember that if you have questions, drop them in the comments, and I will try to address them. But this video is for general education information. If you have specific questions about your specific situation, then the best way to handle that is in a one-on-one consultation with a lawyer in a confidential setting. So that's the smart choice would be to set up a consultation. These videos are meant as general education, not legal advice. I hope that you'll watch more of my videos. I have other videos on different parenting schedules and parenting plans and different issues that come up in divorce. And I hope that they are helpful to you. Thanks for tuning in.